I often have clients come in when they first sit down with me, ask whether or not they have to sign anything or write a check to me for anything, and the answer to that is initially no, and I explain to every potential client that comes in that it is not our practice. I know it's common among most attorneys during the initial interview to essentially slide a retainer across the table and as they characterize it, get that client signed up. It's my view that a relationship of trust between the lawyer and the client is probably the single most important part of that relationship. If we don't trust each other, I can't trust the client to really tell me about what his or her issues are, how the injuries have affected them. I'm going to be a more tentative advocate for them if I don't feel like they're telling me the whole story. Likewise, the client is hiring me and my firm and is relying on my experience to give them advice that they can rely on when the very difficult decisions need to be made. And if a particular client, for whatever reason, whether it's the color of my suit or the way I talk or whatever it is, isn't completely confident that I am capable and willing to give them solid advice, when they have to make that very hard decision about whether to accept a settlement or go on to trial, they're going to be very uncomfortable, and I'm not going to be particularly helpful to them because they're not going to be confident that what I'm telling them has value and is going to help them with their decision. So what I do with all of our clients when they come in is tell them that I will mail them our standard retainer, which outlines our fee agreement, and it's adjusted to a particular case and the complexity of it, and that I will mail that to them after going over it with them in the office, and suggest to them that they take some time when they get it to sit in the comfort of their own living room and read it and understand it. And if they want to talk to a family friend or their spouse, or they have a trusted advisor that they want to help them go over it, or if they want to go talk to another attorney to see what another attorney says, that they should do that, because if they have questions about the retainer or about whether or not they want to hire me, they should feel free to have that consideration without the pressure of being in my office and someone sitting across the table from them asking them to sign a retainer when they're not really certain they necessarily want to do that. So that's our practice, and we don't ask for any initial payment of money, and I can explain, and I do explain to clients what the potential expenditures are in these cases, but there is no upfront payment to a personal injury attorney, and we don't expect one, and most lawyers don't.